Thank you very much, Faiza, for that very kind introduction, and with Amos for putting this panel together, and for my distinguished panel, especially Judge Henry. I have a connection to Oklahoma. My sister got married and moved to Oklahoma a year and a half ago, so I visit Oklahoma regularly. So I'm going to place the practical aspect of how all this works. We all know as lawyers that the foreign law ban violates the separation of powers, the free exercise, the issues regarding freedom to contract, and the supremacy clause. But as a lawyer, as a practicing lawyer, one issue that's very, very important to me is the issue of the separation of powers. This ban basically, essentially what it's doing is divesting judges from their authority to determine what law governs based on 100 years of conflict of law jurisprudence. So we're taking that authority away from the judge. More importantly, for a practicing attorney, they're also taking away the authority of a judge to make findings, factual findings. In other words, without allowing him to look at the surrounding circumstances of certain cases to better understand them, we're also taking away the judge's authority in making findings of fact. And I'm going to explain some examples of how all this functions. As a lawyer, my ability to weave a narrative and present a story to a judge to better understand what are the circumstances surrounding this dispute so that he understands that story and adjudicates it based on this full picture. I'm not able to do that with such a ban. Let's talk about some examples. Sharia comes into play, or Islamic law comes into play in two basic categories. It comes into play as a foreign law. So some examples about foreign law, and I'm going to give you exactly cases that I actually worked on, either as an expert or as a consultant. Over the past 10 years, I've testified maybe 40 times in different courts around the country and prepared more than 100 reports relating to a component of Sharia law or the laws of the Middle East in litigation. So in a tort case, have a case where there's a wrongful death that takes place in a Muslim country. The plaintiffs initiate their case in a federal court in the United States. Well, as we know, based on the conflicts of law, the law that would govern would be the law where the tort took place. So here's an implication where now, with the foreign law ban, what do we do with this particular situation? In another case, a contract is negotiated and signed in Saudi Arabia. When you litigate your case in a federal district in New Jersey, the court is obligated to apply the law where the contract was signed. Another example, an example about validity of a marriage. The majority of jurisdictions around our country provide that the place where the marriage takes place is the law that governs a validity dispute as it pertains to marriage. So now what do we do with marriages that take place in Muslim countries with a foreign ban that a judge cannot even entertain whether this law applies and the marriage is valid? Other examples relating to, let's say, a ceremonial marriage. Ceremonial marriages without a marriage license under New York law is considered a valid marriage. So the judge needs to take testimony on whether this marriage was consistent with Islamic law in order to be able to determine, is this ceremonial marriage sufficient under New York law? So this is one area where Islamic law comes into play as a foreign law, whether it's by choice, by conflict of law, or the place where the tort has taken place. The other way that Islamic law comes into play in a litigation is what we would call extrinsic evidence or parole evidence. And here, what I mean, it's evidence that aids the court to better understand the expectations of the party to a dispute, to clarify an ambiguity, to uncover a fraud, to basically determine custom or usage. The extrinsic evidence here is an aid to the court. Example, you have a couple that get married in New Jersey and they enter into a Muslim marriage contract. Dispute arises, they go in front of the court, and the wife seeks to enforce her marriage contract. Now the judge is looking at this document, has no clue. He's not knowledgeable in Islam or Islamic law. And he says to himself, I have no idea what we're talking about. I want expert testimony to explain to me, what is a Muslim marriage? Offer acceptance of marriage. There's a concept, there's a provision called a dower. What does that really mean? And after the judge looks at the surrounding circumstances and hears this testimony about Islamic law and Islamic culture, Now the judge has a better understanding of the big picture. He goes and he applies state law. He doesn't apply Islamic law. He looks at the surrounding circumstances. Do they comply with all the requirements of contract law under New Jersey law? Was there offer? Was there acceptance? Are there any valid defenses? Was there fraud, misrepresentation, undue influence, coercion? You look at these circumstances. So in the first set, what we talked about as it pertains to foreign law, it's not that foreign law supplanting New Jersey or American law. It's American law dictates that foreign law applies. When you present your case in front of a court, I do many of these cases where there's conflict of law issues, where we're briefing the federal court, here's the law on conflicts in Texas. And based on that, it's really the law of Qatar that really governs, Judge, and you need to make that determination. So it's American law that dictates the applicability of the foreign law. It's not the foreign law coming to supplant or replace the Constitution. Also in the extrinsic evidence aspect of it, you have situations where an estate plan, for example, that provides, in the event of my death, my estate should devolve according to Islamic law. It doesn't have much details other than Islamic law. Well, here the judge needs to entertain or hear testimony on how does Islamic law distribute an estate in order for the judge to effectuate the intent of the testator. So as you can see, Islamic law is very diverse and applies and is relevant regardless of religiosity, or it's more relevant to more religious Muslims, but even non-religious Muslims who, like the majority of us, may marry religiously. Most of my colleagues who happen to be Christian or Jewish or what have you don't go to church or don't go to synagogue, yet they get married, they have a rabbi appear and solemnize their marriage, or go to a priest, or a Muslim who doesn't, you haven't seen him in a mosque in 10 years, brings an imam who solemnizes his marriage or provides a contract for his marriage. So these marriages are entered under Islamic law and under religious law. And if we do not allow courts to consider this, we are doing a disservice in divesting that court of its authority to determine the applicable law, and more importantly, on determining the findings, the factual findings necessary. So in this particular context, as you can see, one thing that's very important, everything I talked about is always subject to public policy. I've been on cases where, on the other side, where I'm testifying because actually the provision that is applicable is contrary to our public policy and should not be recognized by a state court. But in other circumstances, it doesn't violate our public policy and should be recognized. In one particular case, it was a recognition of a Syrian divorce decree. In that particular decree, the court changed custody because the wife remarried. So the court in Tennessee that was considering this said, you know what, I'm not going to recognize it because it would be contrary to Tennessee public policy that an automatic transfer of custody because of remarriage would not be consistent with our public policy. So in other words, even if foreign law applies, doesn't mean that it will control. It all is dealt with within the strictures of our Constitution and our public policy arguments. In a recent case, again, we're divesting the judge from his authority. We're considering judges to be stupid, and we're considering judges that they need direction. A judge in New York recently enforced a $250,000 judgment out of an Abu Dhabi court. And in that $250,000 judgment, it was for a wife for her dower. She negotiated in her marriage contract, at the time of divorce, you're going to pay me $250,000. He divorces, they were in a Muslim country, she enforced it. The husband provided every conceivable argument that Islam and Islamic law violates the public policy of the state of New York. And the judge said, you know what? Some of what you say is correct. It would violate the public policy of New York. But none of those issues are implicated in the enforcement of this particular limited issue about the $250,000 dower that you agreed to. So judges have the tools to look at the issues before them and to determine, can they enforce a contract without violating public policy. A case that I handled in 2002, Odetola versus Odetola, was a case before a trial judge in New Jersey on the enforcement of a marriage contract. What the judge did, in the end, was said that I'm going to apply neutral principles of law as long as the enforcement of this Muslim marriage contract in directing the father the husband to pay the lump sum that he agreed to does not violate New Jersey public policy, I see no reason why not to enforce it. So the judge did his public policy analysis and evaluation, and as long as it passed the public policy test, you have no problem. For example, in France, our punitive damage awards are against their public policy. So they would not recognize a punitive damage award emanating out of a United States court. So we need to keep in mind that the legal subtleties and the nuances are what's missing in this debate. You don't need a foreign law ban to tell you that if an agreement says that you're going to have a polygamous marriage, our judge is not going to recognize a polygamous marriage because it violates our public policy. You can't have a contract that's going to say that you're entitled to lash somebody 50 lashes because he stole something in New Jersey, or anything relating to issues regarding adultery and what have you. These are issues that are not implicated in any of the litigation that takes place around in this country. So in the end, in a nutshell, what you see is that the impetus behind this anti-Sharia movement is nothing but bigotry and discrimination. And this is not a surprise. Most of the proponents have admitted on the record that the target of these are Muslims. The target is Sharia. And what makes this more insidious and more dangerous is that many of them, including Shalami, was quoted in the New York Times saying that he didn't care if they passed the legislation passed. All he wanted to do is create enough friction, enough questions for people to say, what is Sharia? And then people to associate Sharia with something that's so horrendous, so horrific, that marginalizes Muslims and fuels the Islamophobia. That's really the true story behind the anti-Sharia movement. As lawyers, we know that there is no added protection in providing with this foreign law ban. It rather implicates and undermines the civil liberties and the freedoms that we cherish most in this country. Thank you.